Good afternoon or good evening or good morning, depending on where you're at in the world. I am Bob Mata. This is Defense Diaries. I am your host, and today is October 6th, 2025, released here in the U.S., and I am once again, as always, joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all.
So, babe, today we are revisiting Kelsey Fitzsimmons, as there was a emergency appeal that was drafted up and sent off to the Supreme Judicial Court of Massachusetts. And when I first read through it, I had to go back and reread it because they really put it together pretty well and kind of laying out exactly what happened here.
Yeah, I mean, even though we covered the hearing and we covered the judge's order, I had the same reaction. It's like one of those cases where the more you learn, the worse it gets.
Yeah. So for those who may not be familiar with the case, this is kind of the top line of it, just kind of the basic facts. So we've got Kelsey Fitzsimmons, who is a Massachusetts police officer. She was shot in her chest by a colleague. She then goes on to survive 53 days in a hospital with a collapsed lung, broken ribs, damaged liver, bullet fragments still in her body. She then gets released on bail with conditions, and then a lower court judge sends her to jail.
And not for the shooting.
Yeah, right. She gets sent to jail because her injuries made it physically impossible for her to blow into a breathalyzer device. And when she came to court asking for an alternative, the trial judge revoked her bail.
Yeah, I mean, it was partially physically impossible, partially extreme amount of pain that came along with it on the times when it was possible. But yeah, now she is appealing that decision to the Supreme Judicial Court, the highest state court in the land.
Exactly. And we're going to go through this step by step because there's so many layers. The underlying incident, the charges, the bail conditions, and then what happened at the lower court hearing, which, again, we do have that available in our library. If you go to the channel after you share, like, and subscribe, you can find that, where we kind of go through that entire hearing, because the hearing itself was pretty shocking, to be honest with you. Just kind of the judge's demeanor was very off-putting to me. I don't know if it was to you, but to me, she just seemed strange. It was a really weird vibe in there. It seemed like personal attack. It was weird. But yeah, we're going to go through that, and then what happened at the lower court, and then the legal arguments that are being made on appeal.
Right. So it's the Commonwealth versus Kelsey Fitzsimmons. The emergency petition for relief was filed October 2nd, 2025, appealing from the Essex Superior Court of Massachusetts to the Massachusetts Supreme Judicial Court, which is a single judge session.
Okay, so let's start from the get.
All right, so on June 30th, 2025, who is Kelsey Fitzsimmons?
All right, well, she is a North Andover police officer. Before that, she was a corrections officer for over 2 years at the Essex County Sheriff's Department, and she went through the whole path. She was a criminal justice major, and she got that degree at Fisher College. She graduated cum laude, and she completed the police academy, where she was actually the class treasurer.
So, dedicated law enforcement career.
Yeah, you could say that. And then she had a 5-month-old. Well, she had a baby. When this thing went down, the baby was 5 months old. And what's critical in terms of understanding this case is that Kelsey had been diagnosed with postpartum depression in March of 2025. She was actually on leave from the department. She was raising her baby, and she had just been cleared to return to work when this incident went down.
All right. So what prompted everything? What happened?
So her fiance, the baby's father, obtained a restraining order against her, ex parte, meaning that she had no idea it was coming and no chance to respond, and that she wasn't there when the court entered the order.
So did that order require her to surrender immediately?
Yeah, it did. It required the immediate surrender of their 5-month-old baby to the fiance and the surrender of all firearms to the cops. The appeal petition says that the fiance had disappeared for 3 days and then filed what they're calling a false and self-serving affidavit.
So from her perspective, she was blindsided.
Completely. And the order was served by 3 of her colleagues, former colleagues, whatever you want to call them, from the North Andover cops, PD. And then they show up at her house in order to take her baby and her firearms.
Damn. I mean, that's pretty traumatic alone without even getting to the fact that she was already suffering from postpartum depression.
Yeah, it's not a good situation. It's having, like, here in Illinois, we have the sheriff always serves our, like, it doesn't matter what community you're in within a county, the county sheriff is who serves these TROs on people, not whatever town's police department.
I mean, they may have been doing it more like as a courtesy, like, let's, you know what, she's one of us, let us tell her.
Yeah, that's for certain. So the petition goes on to describe what happened next. So Kelsey's approximately 5'3", 110 pounds, soaking wet. In the space of about 30 seconds, she's trying to process the fact that she's losing her child without any say-so, losing her job because of the firearm surrender, and in her mind, she's been betrayed by her fiance.
Right. And then that's where you start getting differing accounts as what went down that day, right?
Yeah, for sure. I mean, like always, you're always going to get 2 sides of a story when you're dealing with, like, these TROs, these temporary restraining orders, which ultimately can bloom into what in Illinois we call them a plenary, which is a permanent injunction that can last up to 2 years, and then you can go in and ask for it to be extended. Yeah, I don't know what the time limit is in Massachusetts. I think we talked about it on our earlier live. I think it may be a little longer. I think it could be 3 years, but I might be wrong on that. So, but according to Kelsey's version, which is what the defense is arguing, she raised her firearm to the side of her own head when this thing went down. So there was a situation where her and it was actually her former partner, go upstairs in order for her to collect some of the baby's clothing and things like that. And at that point, she raises, according to Kelsey, she raised her firearm to the side of her own head in what they described as a half-hearted attempt at self-harm.
Right. But the officer claims she pointed the gun at him and tried to shoot, right?
Yeah. And the problem is that there's no body cameras to support either side, frankly.
Wow. So you went through her injuries. They sound pretty extensive.
Yeah. Yeah, they were definitely extensive. Ultimately, she gets shot in the right chest area, the hemothorax. That's the blood in the chest cavity, with retained bullet fragments in her upper back. She has a collapsed lung requiring a chest tube, pulmonary contusions with active bleeding, grade 4 liver trauma with active bleeding, and then there is a comminuted. Does that sound right?
Yeah.
Comminuted. Yeah, comminuted fracture of the right 12th rib and a fracture of the right 11th rib as well.
I mean, grade 4 liver trauma sounds pretty serious.
It does. I mean, I'm no doctor, but I wouldn't want it.
Nah, I wouldn't want it.
Nah, it
But she
sounds
was in the hospital for a long time, you said?
yeah, for like 53 days, and she still had bullet fragments lodged in her body that they couldn't remove.
So she gets charged with what?
Initially,
Yeah, because I know they changed.
yeah, so initially, uh, so she's charged with assault with intent to murder under Massachusetts General Law, Chapter 265, Section 18B, plus 2 counts of assault by means of a dangerous weapon.
So what did she end up getting indicted on?
Right. So ultimately, they don't indict her on the murder, the intent to murder charge.
I would hope not.
Thankfully. And there was only one true bill that came through, which was a single count of assault by means of a dangerous weapon.
Oh, and it's not that they didn't, it's that the grand jury rejected it.
Correct. Yeah, they
So
tried. They tried.
They
Yeah. Yeah. So, like, ultimately, the prosecutor couldn't even establish a probable cause, the intent to murder in the grand jury, which is, the prosecution's most favorable forum because, they go with no resistance from the defense at all. Typically,
Right.
we
We
always
all
say
know.
it.
Ham
We all
sandwich.
know ham sandwich time. So it's an incredibly low bar. And despite the fact that it was an incredibly low bar, they just couldn't meet it.
Right. They couldn't show any malice or any intent.
Right. So assault by means of a dangerous weapon is a 5-year maximum felony. The petition points out that under mass sentencing guidelines with no prior record, this is a probation level case, meaning the judge could give her straight probation. She doesn't go in.
Right, which all goes to bail when you're talking about like this could be a probationary case. There's no reason for her to run, to take off, to not come back.
Right. And, and she was a cop, so you're thinking, and she was in postpartum. It's like she was diagnosed postpartum depression. So you think these would all be things that this female judge would
Take into
consider.
account. Right.
Yeah. And
And she's maintaining her innocence.
right, of course. So, yeah, in terms of her, Kelsey, she's saying that she never pointed the gun at anyone. Okay,
Right.
which is key to her side of the story.
Look, and at some point I remember there being something, and I thought it was in one of the pleadings or something that they had released that she had to recock the gun. And in my mind, I'm thinking if she had to cock it or do something that he could have thought that maybe she was gonna point it at him. In my opinion, I don't, and it's just like my gut opinion, and I said this before, like, I don't think her partner is flat out lying. I just don't think he's being forthcoming with what happened, or like that he thought it was coming his way, like to make it sound like she was actually pointing it at him, trying to shoot him to justify his own conduct.
Yeah, I mean, it's such a super fucked up situation because, I'm sure the reality, if we were able to get her partner on the show, I mean, this thing like happened in a matter of seconds. This wasn't like some kind of huge buildup. It was all just kind of like blink of an eye type shit. And, I mean, who knows what's going through his mind at that point in time. Anytime a weapon is introduced to any kind of situation wherein law enforcement's involved, it gets hairy, and I mean, I'm sure that this guy has a lot of respect for his former partner. I mean, they work together on the job. We all know that there is that thin blue line that cops typically have one another's back. So I mean, it's hard to know what was going on in his mind. It's really unfortunate that we don't have body worn camera.
Yeah. If he was
Which
a decent
apparently,
guy,
huh?
sorry, I was just
I,
gonna say if he was a decent guy, he would say, "Look, I kind of reconsider it when my adrenaline stopped pumping, and I've revisited it and walked myself through it. And yeah, I thought, it looked like she was getting ready to point the gun towards me. I couldn't take any chances. But can I say that she actually pointed it at me? No.
yeah, I mean, the bottom line when you think about it, though, is he basically took a kill shot. I mean, he knew she didn't have her vest on. She's at home chilling. She's not like she's, raising her kid. this was complete surprise to her, like the shot where it hit was, for all intents and purposes, what I'd consider to be a kill shot. I mean, she's lucky to be alive. You have to wonder if in that moment that there was another option for him as opposed to shooting his former partner. I mean, again, it all happened so
I don't know why
quickly.
the taser doesn't come out when
I
you're
don't know why
in this
taser isn't
situation.
always the first option, frankly, like in every circumstance. I mean,
Like,
assuming I mean, I have
hide behind the
seen,
wall, peek in, see a gun, just fucking taser.
yeah, just tase, just tase. So kind of going back to what goes down. So eventually she gets released from the hospital, and what happens with the bail in the lower court?
Well, there was that bail hearing on, I think it was September 8th, 2025, before the judge in Essex Superior Court. And she's, obviously with the same judge throughout. Um, and that judge eventually, they go back to have her reconsider once she can't actually perform the function. She's having difficulty when she is trying to breathe into this thing. So,
And that thing being what they call a SCRAM device. Now in Illinois, we don't use the one where you have to blow into it. It's attached to your ankle, which even here that creates a lot of issues for people. It's like you can't really shower with it on, and if you do, you can't use any kind of products that have any kind of alcohol because that can give you a false positive reading on it. And like we've had our own issues with the thing that you wear on the ankle, but it's an option for somebody who can't physically, or it's causing them incredible amounts of pain in order to breathe into the breathalyzer, which is what was going on here.
right.
So
So when the judge releases her, she puts her under what they call 58A conditions, which are like the conditions, um, the conditions of pretrial release. And here they argued in the petition, quote, a plethora of 58A conditions more fitting for a career violent offender looking at years in prison.
so what is a 58A condition?
So they deal with the pretrial detention for dangerous persons. It's for cases where someone's considered a danger to others or the community, and the conditions, you know, can be quite restrictive or not, depending on how how dangerous you consider the person here. And one of the conditions here was that SCRAM device that you were talking about.
Right. And the SCRAM is like, so if you guys don't know what that stands for, it stands for Secure Continuous Remote Alcohol Monitor. And like those are always operated by third party companies. So
SCRAM,
meaning, yeah, like so when you have SCRAM involved, you're dealing with an independent company that has
SCRAM,
huh?
SCRAM.
Yeah. Well, I mean, I'm just saying it's not a part of the actual
Right,
probation
right. It's
department.
also the name of their company and the name of the device.
It's the name of the device. I mean, there's different companies that have the device, at least here in Illinois. Like
Oh,
I was dealing with a company that was, in contract with the probation office in Kane County.
oh,
And, they were an independent company. There were multiple companies that had it, but that particular company won the contract. So, but again, in Massachusetts, this particular device that they use is a breath testing device that requires you to blow forcefully into a tube at scheduled times throughout the day.
but why was there alcohol monitoring for those who don't know? Because was there alcohol involved in the actual incident?
Not in that incident per se, meaning that when they went to get the baby and get her firearms, there was no indication that she had been drinking that day. However,
But the
um,
petition does, before you get into the petition states, quote, "Alcohol was not part of the incident in any way."
right, which is factual.
Right.
There were some allegations that there were other days where alcohol seemed to be an issue, where the drinking was heavy, and she had some pretty unusual outbursts in terms of being intoxicated. And like we went again, we went through all that in our prior live on this, and it's clear that the postpartum depression and the alcohol use were causing her problems.
Right.
Like I don't want it to appear that Kelsey was just completely, fine and normal. I mean, she clearly had some shit going
She
on.
was struggling.
At one point, she was struggling, and there's no shame in that at all. It's just the reality of the situation. So, how does that device typically work?
Well, you've got to blow hard in the tube, like you were saying, be able to provide the sufficient breath sample for analysis. And like you said, it tests you multiple times in the day. And in this case, they were set up for a schedule for up to 4 times daily.
Yeah, and like just for a frame of reference and DUIs that we've handled, in Illinois, the way that it goes down when they stop you and then they ask you to take a breathalyzer roadside, that is always basically what Kelsey had to do. It's the same kind of little contraption wherein you have to go and you have to blow. And you have to blow hard. Like we have it happen with us all the time, where one of the first things that I'll ask a potential client is, like, well, did you blow? And they'll say, well, I tried to. And I'm like, well, what do you mean? Well, like I took the machine and I tried to blow and they said it wasn't registering. So a
Which
lot
is
of
something
times
a lot of people do to try and avoid actually blowing.
right, because
They're
in
like,
Illinois,
I'll be weak.
yeah, I'm gonna pretend like I'm gonna blow hard, but I'm not really gonna blow hard. So, but the difference here in Illinois is the difference between a 6-month summary suspension of your driver's license and a year if you refuse to blow. So a lot of times that's why they're not trying to give the state the evidence that's going to convict them, because typically that's exactly what blowing does. It gives them the best evidence that they have because it shows what your BAC level is. So a lot of times people will do that where they're not
Spider,
really able to
stand by.
blow with the yeah, with the force required. And that wasn't the situation here for Kelsey. It was really, she had a problem because she had broken ribs and a collapsed lung.
I missed the damn spider. I knocked him to the floor.
You were trying to kill a spider?
Yeah.
Oh boy.
So yeah, it's gonna make it hard to say the least.
Yeah, I mean, for sure. I mean, because you can't generate the force or the breath capacity that you need to in order to blow. You're going to get all kinds of things like we deal with, like where somebody says that they blew and they didn't blow. So it comes back as they're not performing or they're refusing to perform. So, like, those kind of things will keep popping up as it's not registering at the times that she's supposed to be taking the, to perform the breathalyzer. And that gets reported to the third party company who then reports it back to probation. And that was a part of that hearing that we covered, where they actually put in the person from the SCRAM company who was saying, and probation, they put the probation guy on. He's like, look, this isn't something that we would typically even report back to the court, right? So, but the petition includes a medical opinion from her trauma surgeon, Dr. Parks, who said that the fractured 12th rib can cause pain that persists for several months, and the severity of that varies. And he also noted the retained bullet fragments can cause chronic pain, which is exacerbated by movement, like, say, for instance, deep breathing.
Right. And that was also part of their motion to reconsider in the lower court. Um, they did attach that. So essentially they've established that attempting to use a device causes her physical pain, severe physical pain.
Yeah, there's no question about it. There's no question about it. And ultimately, I mean, she was trying to use it. She was trying to use the breathalyzer. It wasn't that she was refusing to do it. She couldn't do it physically.
And how does the petition describe what happened when she tried?
Well, it said that whenever she attempted to comply, she passed out 8 out of the 9 tests despite the pain, or she passed 8 out of the 9 tests despite the pain.
But they said that she had experienced pain and dizziness for up to 4 hours afterwards.
Yeah, I mean, well, so the 9th one, she couldn't complete it because she just couldn't breathe. So she called the monitoring company, Elmo, to report it, and they told her that they may issue a warrant, but they never did.
Right, so no warrant was ever issued, and ultimately she I thought she completed that one, but maybe that remained incomplete.
Yeah, I mean, on the 9th one, she did 8 out of the 9. and then that one was incomplete. And, after that phone call to Elmo, she's feeling obviously super anxious because they're telling her that there might be a warrant issued. At that point, she's terrified that she's going to be arrested and sent back to jail, despite the fact that she was trying in good faith to blow and to, follow all the conditions of bail. So on the 10th of September, through her attorney, she files an emergency motion to the court. She calls her lawyer and says, "Look, I'm freaking out.
Right.
I mean, this is a situation where I physically can't do this, and it's causing me extreme discomfort and pain. And now they're telling me that they're going to issue a warrant and throw my ass back in jail. I need you to file something."
Right. So they filed a motion to vacate the SCRAM, requested that the court put in some other alternative testing methods. Um, but at the initial hearing, they never really specified what specifically, those were. But the petition does reference urine testing and the transdermal bracelet, which is what we use here.
Right.
Um, And I think that when the assistant chief probation officer did testify that there were, alternatives, a- according to the petition anyway.
Yeah. Which I think he probably testified are routine accommodations. I mean, you got somebody that can't physically do something, and there's medical records to actually back up why they're having a problem. Um, I think that it behooves the court to try to accommodate that, especially because I mean Kelsey's sitting here as always, innocent until proven guilty. So the thing gets filed by her attorneys, and then on September 11th, the lower court has the hearing.
Oh, sorry, I was looking at something about the petition that I was contemplating reading, but um,
That's cool. So, I mean, like at this point, we're going to start talking about the hearing on the 11th, which again, we did a full live on that. But so that's on the 11th in Essex Superior Court, and then this is basically where things go completely off the rails. And this hearing becomes the basis for the appeal that we're going through today. The defense expects, well, like walking in there, like we would be feeling the same way. We're like, okay, this is a no-brainer type of hearing. We're going to go in, we're going to say, look, here's the medical records. We're going to put probation on there, and they're going to, tell the judge what's up, and the judge is going to figure out an alternative to her blowing. And that's not what happened at all.
right, which like you said, is reasonable based on the circumstances. The state didn't bring a motion. Nobody filed anything about, saying that she violated anything or wasn't compliant. So, it seems reasonable.
Yeah, I mean, it was reasonable. And um instead, how the appeal terms it is they describe it as a completely improper nightmare scenario ensued. And you want to talk about a little bit of the testimony that's transcribed in the petition?
Yes. So we have what the assistant chief probation officer, Jeffrey January. He, because probation is usually the entity that would bring the violation. So his testimony, you'd think, was pretty crucial. What did he say, babe?
Well, he testified that there was an incomplete test, and that his first job is to gather information. So he calls Elmo, he gets the details, and he learns that Fitzsimmons had answered the alert to take the test as scheduled, but that she couldn't complete it because she couldn't blow as long or as hard as she needed to. She ultimately completes that test at around 4:20 p.m., about an hour and 20 minutes after the scheduled time.
Right. And she she passed it just later.
Yeah. Yeah, right. So then he goes on to say, and I'm quoting from the actual petition, I observed it firsthand that whatever the injuries are, and I don't know, and actually it doesn't really matter to me. When I was doing the installation process, what I observed was genuine pain.
Right, I mean, he witnessed her trying to use the device. You'd think the judge would have given some weight to his testimony.
You would think, and then he goes on to say that we have all the information. We don't deem that, and we're talking about the probation department, as non-compliant. She was attempting to take the test and she ultimately passed it at 420. So with all that information, that's not non-compliance. That's compliance with her obstacles. That's compliant with SCRAM testing.
All right, so probation officer's telling the judge she's compliant.
Yeah, and not only that, he explicitly says that, quote, we would never, ever would in this case initiate a pretrial violation proceeding based on an incomplete test that was subsequently passed.
But the judge gave pushback.
Oh yeah. Yeah. She argues with him. It wasn't just like pushback. She gets into like a healthy debate with him. Judge McCarthy Naaman says that, well, that's your position. And this is a quote again from the petition. That's non-compliant. It's really up to the court to determine whether someone is compliant or not with conditions of release.
Which I guess is debatable because probation typically has the expertise in the compliance department. But was there a bigger issue that came up?
Well, yeah, the judge goes on to accuse probation of creating a testing schedule when she had ordered, quote, random screens. Now, this becomes a massive argument where Officer January has to explain that probation always creates schedules unless the court specifically orders completely random testing.
And he explains that it's like for convenience, it's just easier for them. But the judge seems to think like that this was a violation. He says it was standard practice that they do this, but the judge was responding like this was some kind of violation of her order.
Yeah, I mean that's the way she felt, and like that it was a pretty heavy duty debate, and he was saying, look, I hear what you're saying, Judge, but it's really not you as the sitting judge who decides whether or not initially whether there was non-compliance. That's us,
because she wouldn't even know about it.
Right? She wouldn't know. She would have no idea. She's not sitting there monitoring all the defendants that are on her docket and their SCRAM. Like the only way she ever knows is if probation comes and says, okay, they go to the prosecutor and they say, all right, well, there was non-compliance. She's not doing her SCRAM. Prosecutor then filed something seeking to revoke bond, and that's how it gets in front of the judge. So none of that happened here.
Right.
So in the hearing, the defense repeatedly asks about alternatives. The petition cites multiple timestamps in the recording where counsel mentions alternative testing, but the judge shuts it down.
Yeah, and what the prosecutor and the Commonwealth, they didn't seem to have an issue. The prosecutor says there's no evidence to submit other than the argument that I talked about in the Commonwealth's brief, and in light of the court's reasoning, releasing the defendant, testing should be done. I mean, that's basically all they had to say, right?
Right. I mean, bottom line is the Commonwealth just wants the testing to continue.
And not asking for revocation.
Exactly. There's no allegation of a violation. So there's no request for a surrender hearing, no request to revoke bail. The Commonwealth just wants her to keep being tested.
Yeah, so it's just bizarre. No one's asking to go to jail and the judge just gets hostile. What does the petition say about her hostility?
Well, the petition says that she, and this is again a quote directly from the petition, that she berated and shut down the probation officer, cut off counsel, and walked off the bench while undersigned was arguing for his client. So in the middle of defense counsel arguing, he just stood up and dipped.
Well, look, in fairness, she gave her ruling. Defense counsel was shocked and horrified by it and tried to stand up and start arguing again, but yeah, she left in the mid argument, like while he was still speaking, she walked off.
Yeah, I'm not going to go with that in fairness bullshit. Her job Her entire job is to do what she's doing right there.
Yeah, but once she rules, that's supposed
How
to be
can
the
she
end.
rule without having all the evidence and argument before her?
I kind of, gave a little pushback about I thought that the lawyer should have done more at the time. Like he should have, specifically he had probation there testifying. Why didn't he specifically have him testify about the available alternatives? Why didn't he specifically give what he gave in the motion to reconsider, you know, like the letter from the doctor? And maybe you should have taken time to get something more from the doctor to say that she is still having this difficulty, or asked to continue it so that they could get more medical, information.
Yeah, I mean, I agree with you that Bradel probably definitely should have like specifically given alternatives. He didn't for whatever reason, especially in light of the fact that he had probation there. However, I'm not giving the judge a pass on this one. I'm going to agree to disagree with you there. Her walking off the bench is just not professional
No, I agree. I
in
agree.
my opinion.
I
And
agree. In light of everything else that had happened, the way that that hearing went down, I completely agree. I just didn't want to make it sound like mid argument during the appropriate times for argument, she walked off, because technically the time for arguing had passed.
well, I mean, it seems like Bradel still had shit to say.
He did. He
Yeah.
did.
So ultimately, what happens is the trial judge issues an order revoking her bail and surrendering her to custody for 180 days as a danger to the community.
Because she couldn't blow into a breathalyzer due to being shot in the chest.
That's the bottom line. Yep.
All right. So what did the defense do after that?
So they immediately file a motion for reconsideration on September 11th, same day as the order goes down, right after the revocation. And then on the 15th of September, they filed a supplemental filing that included a letter from Dr. Parks, her trauma surgeon, explaining the medical situation in detail.
And that's the quote that you read earlier. So and that's where I'm just saying, like, hey, maybe you should have had that stuff going in. And I understand, like, you don't expect it. It's like I can kind of give him a pass for that, but like once you start seeing pushback from the judge, I feel like it's the time to be like, and he had the probation officer there. He could have gotten some more evidence in with him, but that you say, you know what, Your Honor, yeah, I'd like to continue this because I think that it would be helpful to the court to get something more. I don't know, just the way that thing, went down. So, and I
Well, I
know,
mean, even in your world right there, had all that happened, if if we're looking at what happened next, which is that the judge denied reconsideration without a hearing. So she at that point she has the shit from the doctor talking about what she was going through, what the process was in terms of her getting shot and the surgery and all that stuff. She now has that, and then she denies it without a hearing. And in the written denial, she says, and this is again quoted in the petition, quote, after a thorough review of all the arguments and submissions by the Commonwealth and Fitzsimmons, the conclusion remains unchanged, regardless of Fitzsimmons' claimed physical limitations.
claimed.
Yeah, right. Despite medical records, doctor's letters, the probation officer's eyewitness testimony, and affidavits from Fitzsimmons and her mom, that denial prompted this appeal.
All right, so now it's going up to the Supreme Judicial Court.
So, what's the procedural posture?
Well, it's an emergency petition filed there, and they have like uh, their power to hear this because it is something that falls within their power. So the appeal goes to a single justice first, not the full court.
Okay. And what is a single justice? Like, what does that mean for the people?
It's one justice of the Supreme Judicial Court who can act individually on an emergency basis. Um, and the petition cites case law that establishes and specifically addresses like that this is appropriate to be heard before a single justice over bail appeals.
And I mean, ultimately, I think the concept being that it's going to be quicker to just have it go up to a single justice instead of all of them, because then it's a longer process, and the opinion you've got concurring and dissenting opinions, potentially. It's just a longer process if you have multiple justices involved as opposed to a single, right?
Right. And they do this because they know, like, the court recognizes that relief in this type of case must be speedy if it is to be effective. And a single justice can decide the bail issue directly. They don't have to remand it back to the lower court. They could make the decision right there. So, babe, what are the main legal
That's an
arguments?
important point. You know, it's like, because sometimes what you'll have with respect to an appellate court is they'll say, okay, I'm going to remand it back. This is our finding on it. We feel that you messed up on the law a bit here. We're gonna correct you on it, and then we're gonna send it back to you to do the right thing. But what this is saying is that the justice themselves can make the decision as to what to do in this particular situation.
Right.
So
And here's the, just so you can read it from here. This is the what she's respectfully asking the court to do. Or do you want me
right.
to?
So yeah, if you want to go through it.
All right. So Miss Fitzsimmons respectfully requests the single justice to review the full audio hearing provided herewith, take notes of all such instances, and vacate the trial court's order. She requests that the single judge, one, address the bail determination de novo. So de novo just means, like, not giving from their own perspective, brand new, not like a high deferential to the other judge. Um, so it's just taking into account the facts that are newly presented and exercise an independent judgment, and not send it back to the trial court. Two, grant Miss Fitzsimmons liberty with personal recognizance and stay away order under Section 57, no finding of dangerousness required, or Section 87, bail terms imposed with agreement of the defendant of the bail statute. Three, or other such non-incarcerative relief in the alternative if the single justice deems 58A conditions necessary. That means, like, if you find her dangerous and you've got to give some conditions, then do some other ones that don't involve incarceration. And four, send the case back to the Essex Superior Court before a different judge.
Mm,
They're like, that's it. We don't want this
mm,
judge. We're done with
mm,
this judge.
mm. I like that. I like
Yeah.
that. I wish they would have done that in the Delphi case and Richard Allen's case when it went up to the Indiana Supreme Court.
Well, they did try.
Yeah, they asked for it. They didn't argue it in the oral argument portion of it. Like, it wasn't even brought up at all. It shocked me. I'm like, man, that would have been like,
I got to be right back. Sorry.
you get limited periods of time in terms of how much time you get for oral argument up in front of, like, the appellate court or the Supreme Court. And in that case, they never even brought up the fact that it should not go back to Gull. Like, Gull should be removed from the case. She fucked it up. She hasn't kept a docket clean. She's not granting hearings. She's not preparing orders that are sufficient in terms of why she's ruling a certain way. She would just simply say denied without hearing over and over again. So that should have been done here. So it's good that that's what they're asking for here. Whether or not that's going to be granted is a whole different thing. So ultimately, when you're kind of breaking down what the arguments are, there is, again, first, there's a statutory violation. Okay. And that is where they're saying that the Mass General Law, Chapter 276, Section 58B, governs revocation of a pretrial release. It requires the judge to find two things: clear and convincing evidence of a violation, which we know didn't happen here, and there are no conditions that would reasonably assure safety or compliance. All right. And here, again, there's no violation. She came to court seeking an accommodation. And the fact of the matter is that alternative methods do exist. So the finding that no conditions would work can't be supported. And then they shift into the ADA argument where they're claiming that this is American with Disabilities Act violation, which is, specifically Title II of the ADA prohibits discrimination against people with disabilities in state and local government services, programs, and activities, which would include courts and pretrial services.
Right. I
So,
mean, so they're arguing Fitzsimmons' injuries constitute a disability, that she's got a physical impairment that substantially limits a major life activity, breathing. The
yeah.
the trial court required her to comply with a condition that was physically impossible or medically inappropriate due to her disability and refused to provide a reasonable accommodation.
And I mean, in your mind, could you think of any reasonable accommodations?
I mean, the same things they're talking about: urine testing, the transdermal bracelet, in-person check-ins. The petition cites the Department of Justice guidance specifically addressing ADA requirements in the criminal justice system.
I mean,
And
is
it
this a super novel argument?
I mean, not really. Federal regulations require courts to make reasonable modifications, and the failure to accommodate with the punitive consequence of detention is arguably a clear ADA violation. But I mean, it's got novel aspects to it. I will say there are
Yeah.
novel aspects to it.
Well, I mean, I'm glad they brought that as one of the claims because I think it fits here. So, getting into the third ground a little more thoroughly, what was the third ground for appeal?
Well, like the judicial misconduct they talk about, the
Yeah.
petition argues that the judge violated multiple norms, berating witnesses, shutting down the probation officer, walking off the bench mid-argument. Again, that one, you know,
Yeah, we know you're not so convinced of that one. We get it.
I mean, I think it was inappropriate, but I think the court is gonna give her a pass for the
How
reasons
would
I
you
said.
feel if it was you? Like this is not you go into that hearing not thinking it's going to be combative, right? I mean, like the biggest takeaway from that day is the state isn't saying "fuck you," we want her revoked. Like that's the big like anytime we go in and we filed a motion and we go talk with the state prior to the judge getting on the bench, they're like, yeah, we're not objecting to it.
Right, it's like one of those rare situations where the state and the defense agree on a sentence.
right.
And they asked the judge, "All right, sentence him to 12 months." And then your client gets that warning that you tell them they always get, "But don't worry, you know that I can do whatever I want, that I'm not bound by this. You still wanna plead guilty?" The guy says, "Yes." And then the judge says, "Well, I'm disregarding the,
Right.
recommendations of both the parties, and I'm gonna give you 7 years."
Right. Which is like what happened here, basically,
Right.
like so
But they
um
also talk about her accusing the defense of manipulation and making factual errors in her written rulings. And before you get to these factual errors, this whole manipulation thing is fucking shocking to me because they're like, oh, well, she knew she'd have some breathing problems when she left, I guess is why she's saying it was manipulative because she did not raise an objection to SCRAM before. She let herself get released and then come back and say, I can't do it. Just because you have some problems breathing, just because you've got some pain, doesn't mean outright that you are going to be either incapable or in such extreme discomfort, pain, agony that goes on for hours and literally is affecting your health. You're not, how the fuck are you supposed to know that going in? Like, this
you can't.
manipulation thing is so far out of left field. I honestly think that that is going to be something very helpful to them, that the court will find there's no factual support for that. It's an unreasonable statement by the court. But
Yeah.
what were the factual errors?
So, well, the judge claimed that there was no medical evidence when there was. She said the defense didn't propose alternatives when the transcript shows they did multiple times. And then she said probation created a schedule when she ordered random testing. But problem for the judge is there is no such order in the record.
I'm just gonna say they didn't do a good job of they said, "We want you to put in an alternative. We want you to put in alternatives. There's available alternatives," but they never got into what those alternatives were. They could
Yeah,
have
they
done
never
better.
articulated,
Right.
the different things like we just talked about, urine tests, coming in, check-ins, all the other
Right.
shit,
Some of it I
transdermal.
think was in the email, which gets to your fourth ground about evidentiary errors. So what was some of the evidentiary errors?
Well, the trial judge said that the probation officer's email wasn't evidence because it was hearsay. And what's the rule about hearsay in pretrial motions, babe?
Yep, it's allowed in, and we went over the rule. We went over Massachusetts rule explicitly before. It does allow hearsay in bail hearings, especially if it is of something of a reliable, if it's reliable. And here you're talking about an email from the probation department that everybody there knows that's the probation department's email, and the guy was in the courtroom. I just don't know why the lawyer didn't have him say the words in the email.
You just can't stop casting shade on
I'm
Brady.
sorry. At the hearing, the prosecutor says the words. Well, when the judge is like, "I'm not considering an email," she's like, "Oh no." She was like, "State, what do you have to say about this email they're trying to give me?" And the state's like, "Well, the guy's here in the courtroom, so I don't think it's an issue." Basically saying, well, they can just call him to say it. And then he actually started giving testimony, and the defense never asked him those questions.
Yeah, I mean, look, as far as the fact that she's saying that the email wasn't evidence because it's
That's
hearsay,
wrong.
yeah, it's a basic error. And ultimately, at the end of the day, the statute says that the rules concerning admissibility of evidence in criminal trials shall not apply to the presentation and consideration of information at the hearing, and the judge shall, not can, shall consider hearsay. So, plain and simple, the trial judge applied the wrong legal standard.
Is there anything else to the appeal?
I mean, there's the safety issue. The petition includes an incident report showing that on September 24th, another inmate threatened Fitzsimmons because of her law enforcement background. Everybody knows, if you're a cop,
In
you don't want
jail.
to be in jail. It's not a good place for you. The report quotes the inmate making specific threats.
Right. So she's being targeted in custody. And
Yeah.
he definitely made that argument that it was unsafe for her. Like, I remember that from the hearings, that it was unsafe for her as a former correction officer as well, but as a police officer in jail.
Right. All right. So you kind of went over it briefly, but what is the defense asking the Supreme Judicial Court to do?
So those four things: the bail determination de novo, for them to make their own independent decision, grant a release on her ROR, personal recognizance, with the stay away order, and that if the court thinks some conditions are necessary, impose non-jail alternatives, something less than incarceration, and send it back for a different judge.
Yeah. I mean, can they ask for a different judge on appeal?
I don't know. I mean, it seems like, given the alleged judicial misconduct, that they can, and the petition documents the trial judge's behavior extensively and argues she cannot preside fairly over the case going forward. So I think it's something they can ask for.
Yeah. And my question is can they send in, because like the problem with transcripts when you're just reading a transcript is you
Well,
don't
they've
get
got the audio. They sent the
Well,
audio.
that's what I was gonna say. Like that's what you really need, because a transcript does not in any way, shape, or form give you any inkling of what the tone and tenor of this thing was, and that's critical here. I
And
mean,
that's why the petition does ask them specifically to review the audio, and made the audio part of the record.
yeah. So, if you had to take a guess, like at this point, what do you think is going to happen on this appeal?
I think it's a strong appeal. The statutory violation is clear. The trial judge revoked bail sua sponte with no violation alleged by probation or the Commonwealth. And the statute requires a finding that no conditions would work, and the judge never considered alternatives.
And to me, the ADA argument seems compelling too.
Yeah, it does. I mean, alternative testing methods exist and are commonly used. Refusing to accommodate a documented disability and then incarcerating someone for an inability to comply is exactly what the ADA prohibits in government service. I mean, the fact that probation and the prosecution weren't asking for revocation, it's definitely huge.
It is. It's unusual. I mean, typically
like if we have that situation wherein you were just talking about where we've worked out kind of a negotiated plea and we're going and telling our client, look, this is the plea that we've worked out. However, the judge isn't beholden to it. The judge can still do whatever they're going to do.
So, but here's
Typically, we're always of the mindset, but they usually agree to it.
right. But so I had that happen. I mean, usually the way to avoid that is with what's called a 402 conference here, where you get kind of the judge to sign off of it ahead of time. But you don't do that in a lot of standard like cases. It's like it's
Right.
not the norm, like you only need it if there's like something unusual and the state has to agree. But in any event, I had a case once where I could see the judge sort of like here. He could see the judge is giving him like this judge is about to fuck my client,
Right.
and I heard it in his voice. He asked a question to the state, demonstrating him being shocked at this deal. So when he asked for mitigation, I went way over above what I would typically say because I saw that in his eyes and I heard that in his voice. And then I watched him sort of be like, okay, that does it for me, you know. But luckily we've never had that situation where we have an agreement, and as most lawyers do, like you kind of tell your client that it's up to the judge to accept this, but they always do, but it's a possibility, but it's sort of a possibility that typically gets kind of brushed to the side in the same breath. So, yeah, I mean, here everybody was going in to solve a problem, and instead she gets 180 days in jail.
Yeah, and I mean, just remember this fact that this wasn't a petition filed by the Commonwealth for revocation of her bond. I mean, like that, you cannot forget that part. Like this is her lawyer sending off something saying, look, she's having a really fucking hard time blowing into this thing. Can we come up with something else so that she's still able to comply with the conditions of bond?
And it should scare the defense too, because we touched on it earlier. This is probation eligible, but you've got a judge digging in this hard. She is about to slam your client. But typically, the fact that she is probation eligible should be something considered in bail. I mean, do you think the appellate court's going to take into consideration the underlying case itself?
Yeah, for sure. I mean, this isn't a murder charge. I mean, that was rejected. They didn't get a true bill. They tried, they didn't get it. It's a single count of assault by means, which, has a 5-year max, where the grand jury absolutely rejected the serious charges. Alcohol wasn't involved, at least in this particular instance. And she'd be like you said, a probation candidate if she was convicted, meaning she doesn't have to do jail time. You can get a sentence where it says, okay, I'm going to give you straight probation, meaning you're not going in. At this point, she'll have time served, while they're litigating this stuff anyway. So if the judges say, okay, well, I'm going to give you 20 days and she had 20 days in, it would be
Right.
time served. And then the judge could say, okay, well, I'm going to give you a probation for the rest of it, reporting probation. There'll be a lot of conditions of that. But,
Right.
it's the strength of the Commonwealth's case matters for bail determinations. And with no body cameras, frankly, it's a tougher case for them.
It's a
tough.
he said, she said against 2 police officers.
Right.
It's really what she meant and what he interpreted. I mean, that's the way I see it. It's what she meant to do, what her intent was, and how he interpreted the situation. And they can be 2 completely different things.
Yeah. Yeah.
So when will the single justice decide?
Well, I mean, you can't nail it down to a day, but considering it's an emergency petition, they should act relatively quickly. I mean, the entire point of it being an emergency is you get speedy relief for
Right.
somebody who's incarcerated.
Right, and they have this set up for bail situations for that purpose, so it should be speedy because otherwise, your 180 days could be gone in your typical appeal process, but it's also possible that it could go to a full panel. I think it could. The petition notes that um, questions of law arising under a single justice bail determination can be reviewed by the full court on exceptions, report, or appeal. So I guess if there's a significant legal issue, if the single judge finds one, we could see a full court review. I mean, at the end of the day, it raises fundamental questions about judicial discretion.
Yeah, it does. It does. The trial judge essentially said, I determine compliance, not probation. Oops, that's not correct. And she ended up revoking bail over the objections of everyone involved.
I mean, technically I guess she is right, but the point,
She's the judge.
right, at the end of the day, but again, the point is, and I don't think this is something the appellate court's going to focus on. I think the appellate court's or the Supreme Judicial Court's going to be like, yeah, the judge is the one who gets to decide whether it's compliant or not. But the law requires compelling evidence, and this evidence was not compelling based on what they were saying. But practically speaking, the judge doesn't know this exists. The judge doesn't determine compliance until probation tells him somebody's non-compliant.
Yeah. Yeah, 100%. All right. Do you want to dig into the case law a little bit?
Yeah, it's important because, appeals live and die on precedent. So you've got the jurisdictional question. I think that one's kind of a no. It's established, that they can exercise their independent judgment without sending it back to the trial court. The court specifically said, quote, relief in this type of case must be speedy if it is to be effective. That's the Comesso case that they keep citing. So the courts recognize that if someone's wrongfully detained, you can't wait months, and you get to do this.
Yeah, exactly. And they said that bail determinations, must often be done in haste without that full inquiry and consideration which the matter deserves. So the single justice can take a fresh look.
Yeah, there's strong precedent. It's been on the books for about 50 years. There's also some other cases that both accept that a single justice review of bail revocations without questioning jurisdiction, and a full bench heard those cases on the merits. So there's no real dispute about whether the judge can hear this.
Yeah, I'd consider that to be settled law. So the question is, what will a single justice do with it? I mean, let's kind of break it up. So let's talk about the statutory violation argument under the 68 or section 58B.
Right. And I can, I was going to bring up 58B, but I think we can just kind of get into it anyway. So the judge is that the argument that they're making is the judge didn't file the law for revoking bail under 58B, which says you need to find two things. First, clear and convincing evidence of a violation. That right here, that's where I'm saying, like, all right, whether or not she gets to make the determination, I think a court at the end of the day is going to say, yes, that's the judge's, that is within the judge's purview. But you need clear and convincing evidence of a violation. And that, we don't have that here because she did complete the test, and it's not a violation if you're not physically able to do it. It has to be like, an actual violation. Second, they have to find that no conditions would reasonably assure safety or compliance. And the petition says neither of those findings were made.
Yeah, and the key case that was used here was Josh J., a juvenile v. Commonwealth, which is a 2018 case. And in that case, and I'm quoting, they said, requiring that bail be revoked only after finding that there is no combination of conditions that would allow the defendant's release furthers the bail statute's purpose of establishing the right of the accused in most circumstances to be admitted to bail.
Right. Oops.
It is right.
I was looking at something, I was trying to look at something, but
what are you trying to look at? Tell us. We're all dying to know.
no, I was seeing if I
dying to
needed to, read anything from 58B, but I think we're good. So the Supreme Judicial Court has said you actually consider alternatives before revoking bail.
Yeah. And I mean, look, let's be honest. That's the defense's reading. Okay. So The case also cited Commonwealth v. Finelli, which is a 96 case, which established the presumption in favor of bail.
I mean, that's universal. There is a presumption in favor of bail in every state, and it's no different in Massachusetts. Even if this wasn't a revocation, they would need to have made those findings in order to detain her and say, no, she's not entitled to bail. So, it's strong on the facts. Nobody alleged a violation. And again, even if there wasn't clear and convincing evidence of a violation. She came to court voluntarily seeking accommodations, and the probation officer testified she's compliant. But what do you think the Commonwealth might argue?
Well, I mean, if I'm the Commonwealth, I'm going to argue the judge has discretion, plain and simple, to determine compliance regardless of what probation says. She's the judge. I'm the judge. I can do whatever the hell you want. I'm the judge. So, I mean, that's what their primary thrust is going to be. And the judge actually said this at the hearing. It's up to the court to determine whether someone is compliant or not.
Right. And then, like we said, it's kind of debatable. The courts do have the ultimate authority, but probation has the experience in monitoring. But the bigger problems with the second prong, because alternatives exist and they were never considered. That seems hard to defend.
Yeah, it does. It does seem hard to defend. And it is. Because look, urine testing is standard. Probation officers flat out said that alternative methods are completely routine. And how do you argue that no conditions would work when you've never considered readily available options?
You can't. And even though I'm saying, well, they didn't really flesh them out specifically, the judge doesn't live in a vacuum. She knows what, other alternatives are. She didn't like, anything that required her to leave the house, which I think the court will find unreasonable, because if they've got her on GPS monitoring, they can know she left the house, went from house to probation, like that. The not wanting her to leave the house because she's on like house arrest, or wanting her to be in the home during her release, it's kind of ridiculous to say, I don't want her having to go to probation. Like, what? Why?
Yeah.
Why?
Yeah. I mean, at the end of the day, I think that the Commonwealth's best argument would be that the judge did consider them implicitly and rejected them. But the problem for the Commonwealth, there's no finding to that effect in the record. So it's going to have to be implied, because she didn't actually say it on the record. It sounds very Gull-like, very Gull-like.
Right.
All right.
So,
you want to talk about the ADA claim?
yeah, I mean, we kind of talked about it before, it's not novel, but applying it to the conditions of bond, like in this specific way, is sort of novel. The, Title II prohibits the discrimination against people with disabilities in state and local government services, and regulations require reasonable modifications to policies, practices, and procedures. The petition argues her injuries are disabilities.
Yeah. I mean, under the ADA, a disability is defined as a physical or a mental impairment that substantially limits one or more major life activities. And as you've aptly stated, babe, breathing is explicitly listed as a major life activity in the ADA amendments. I mean, I can't really think of any other activity that's more important than breathing.
Right. So you got a collapsed lung, a broken rib, bullet fragments, that substantially limits breathing. I mean, again, the judge doesn't live in a vacuum. She knew this woman's injuries. She knew she was hospitalized. I mean, she's just like saying, well, they didn't put it in the record. They didn't give me further medical information. This just says that, breathing can be hard. I mean, then don't be like a total tyrant about it. Then say, you know what, I'm going to continue this for 2 days and give you a chance to get additional medical information. She could have continued it for 3 days, for 5 days, whatever. It's just absurd, the way that she handled it. It really, really, really is.
It felt like spite. You know what I
Mhm.
mean? Like that was how I felt, that it was like a spiteful thing that she was doing. And I didn't really understand why, like does she hate Bradle. You know, like,
Right.
you always have to, like, I'm wondering why this judge is coming in so hot. And, I have no idea. I have
Right.
no idea. I
And
mean,
I'm
for all I know, Bradle's never argued in front of the woman. So who
yeah.
knows?
And I'm sure that the Commonwealth will argue much as the court did, in its like written ruling that monitoring was essential to a release. And without that testing, they can't ensure the same level of monitoring. But again, alcohol wasn't even involved in the incident at all. So the monitoring of alcohol is not as significant as it would be if this was a case that involved alcohol. It's like someone that you want to say, all right, she has issues, she's been getting into issues with alcohol, so let's have her not drinking alcohol. But when the crime doesn't involve any alcohol use, it's not as important. So you can monitor it. Maybe it's not the best monitoring, but it's sufficient under the circumstances.
Yeah. I mean, 100%. And ultimately here, yeah, I think that the counter argument, and as we're covering this today, I have not seen any kind of response from the Commonwealth with respect to this. I mean, we know that even though on the day of the incident, there was nothing alcohol related happening, but we know that factually there does exist evidence that there was a couple of alcohol related or alcohol fueled things that had occurred at different times with Kelsey. So whether or not, I mean, do you think that those will even make it into the argument? Because I don't
I
know that they were brought up during that particular hearing. I mean, can they dip outside of the hearing itself and bring up other shit?
I mean, if it's in the record and the judge was knew of it, maybe, but I think you're right. I think that's going to cut against the Commonwealth and the judge in this case because there wasn't anything on the record about why it was in there. But it might have been in another hearing that they would have gotten, the stuff too. And the petition does acknowledge that the bracelets, the transdermal bracelets, they're not available in Massachusetts, although the urine testing definitely is. But I don't understand why, even though they're not using them in Massachusetts, why they couldn't have put someone on to say these exist and we can get them very easily. It's not like a whole separate process needs to be set up because SCRAM you know, offers that service and they can monitor it from anywhere. So,
And they could definitely, piss tests are available everywhere,
right.
like everywhere. I mean, they're a pain in the ass. So you got to go
Right.
to
And
a
if you're
spot.
talking about ADA, making an exception, all right, you don't want her to leave the house, then so be it. You have to accommodate her by having a probation officer go down to her house 4 times a day randomly.
Yeah, for
I mean,
sure.
that's it. That's it. You don't want her outside the house, then send them to the house. Not, I don't want her outside the house, so I'm sending her to jail. You pay people to do this.
Yeah. So, I mean, in theory, that argument by the Commonwealth should fail. Because I think the ADA argument probably is the strongest in the petition,
I
frankly.
don't know. I'm not exactly sure if it is. Now, the evidentiary issues, the judge said the probation's email was inadmissible hearsay, which is an error of law, as you went over before. You went through like what the statute specifically says. It seems pretty clear.
It does. And it is. I mean, the judge's statement that she gives the email 0 weight. Oops. Oopsies. Because it's hearsay. That absolutely contradicts the statute.
So the judge in her order cited Commonwealth v. Abbott, a 2010 case, which required good cause for hearsay and reliability. But the petition goes through, and I saw this on my own, that was superseded in by a later case in Commonwealth v. Henderson in 2012, where, and I'm paraphrasing, if hearsay is substantially reliable or trustworthy, you do not need to show the good cause for not presenting the live witness.
And I mean, the probation officer's email was reliable, I would assume.
I mean, it was contemporaneous documentation from an official source, and he testified live to corroborate it, although he wasn't asked to corroborate it. But I mean, they were kind of discussing it and that he was the one who sent it. I don't know.
I mean,
So,
the dude's a fucking state employee. I mean, he works for the government. The probation office is a government employee. Their checks come from the county. So, I mean, if that's not liable, I don't know what it is.
Right.
Like,
The email
so
should have been redundant, but for whatever reason, they didn't put in his testimony on the stuff that was in the email. You know,
yeah.
so I do actually think it's a a strong argument because she didn't consider it, and she could have, and it set out the very alternatives, alternatives that the defense is bringing up. But let's talk about judicial misconduct.
Okay.
Now, this is unusual to include in a bail appeal.
Yeah, it is. But the petition includes it as grounds for reassignment to a different judge, trying to get rid of the judge. Now, here in Illinois, what is it? Within 10 days, we have the defendant by right. It's a matter of right within 10 days or before any kind of substantive, and there's always some kind of dispute as to what constitutes.
This would be substantive, I think.
Yeah, this would definitely be substantive.
I mean, typically bail wouldn't.
For
But
a change of judge, you can ask for a different judge. You can say, I don't, because we're familiar with the judges in our counties that we practice in. And if we get a judge that we don't like that draw, we can go in and file for immediately getting a different judge assigned. I don't know if that's the case here in Mass. And
Right.
at this point,
and they put that time limit and before a substantive ruling so that you're not just being like, oh, fuck, this judge hates my client. This judge made a shitty, like that you're
right.
not basing it on something specific that happened in your case. You're just basing it on, this judge is a big no-no.
So from what we know, what is the standard for judicial misconduct in Mass?
Well, most of the deals with like in the context of requesting reassignment, but they're arguing the judge cannot preside fairly going forward. And again, they're pointing to the stuff that you mentioned earlier, walking off the bench, berating the probation officer, accusing the defense of manipulation, and making these factual errors in the written rulings, which again, I think some of them the court may see, or at least acknowledge there was no clear and convincing evidence. But, courts are reluctant to criticize other judges, and the single justice might address the legal errors without explicitly finding misconduct. What case did we see it in where it went up and the court, like in the concurring opinion or the dissent, they actually said they thought a new judge. Was that Massachusetts? They thought a new. Do you remember what I'm talking about?
Yeah, I know exactly what you're talking about.
Maybe someone in the chat remembers.
Yeah, like we talked about it. It was like
look, somebody already answered.
What was
Aaron
it?
Spencer.
Yes, exactly. It was during the gag in the Arkansas Supreme Court's gag opinion. I think the problem was it was in a concurring opinion. It wasn't in the opinion itself. Right.
It wasn't in the majority. Right.
Yeah.
But it was still, so it can happen, but it's very, very,
Now we've kind of heard your initial gut reaction to the judge dipping mid argument. I mean, do you think that that's a completely where are you getting this concept that like she had already ruled, he was just continuing to squawk?
She did. And after he ruled, he was like, whoa, and then he starts busting out with some shit.
Well, that seems like that's going to be a shitty argument then. Like, I mean, the appellate court's gonna be like, well, judge already ruled.
Right. And even if the panel or the single judge, I guess, thinks that it's something like in the back of their mind, they may be like the same way we're saying, like, yeah, but based on the way this thing went down, he should have just given her a chance to say something more. But they're never going to make that the reason by any stretch. You're going to be like, well, your time to argue had passed, but but I kind of want to circle back. All right.
Sure.
So like case law, like after like analysis here. So I want to dig into something that's important.
Okay.
The judge is calling this a motion to reconsider under 58 58A4. So that's
Mhm.
the initial determination of bail statute, not a revocation under 58B. And that matters a lot. So like
Why?
we've been kind of going on the analysis under 58B, which is what they do in this petition, because they're saying, look, the judge is revoking it, and then she's just trying to reframe it as, oh, this was just reconsideration, you know?
Mm.
And to be honest, there's some complexity here that makes the like initial position that under 58B, this is kind of like a slam dunk. But my immediate reaction was, this is just relabeling to avoid the statute's requirements, the requirements under 58B, which explicitly govern when someone who's been released goes back into custody. That's literally what happened here.
Yeah.
She's released September 8th. She's detained September 11th. That's a revocation, regardless of what you call it.
Right. It reminds me of when McClelland and anyone from the state kept calling Richard Allen's his detainment circumstances. They kept saying he was in solitary confinement, and they said he wasn't in solitary, he was in a single person cell. It's the
Right.
same fucking thing. It was like it was them just trying to frame it in a way using some words that didn't make it sound as horrifying as, but I mean, it is what it is. If it looks like a duck, it quacks like a duck, it's revocation. And that's exactly what this is. 100%.
Right. So, like my initial thinking is like if the court can just avoid 58B's stricter requirement, clear and convincing evidence of the violation, we talked about that, which I don't think exists here, finding that no conditions would work by just calling the detention reconsideration, then 58B becomes completely meaningless. Any judge could release someone and then immediately reconsider and redetain without making the required findings.
Yeah, it kind of seems like an obvious loophole now.
It does, but then I started looking at the judge's order again, okay? And
Okay.
she is saying that it was reconsidered based on new evidence. Change in circumstances. All right. So let me take a step back. I couldn't find any cases. I did some research that actually say like that directly addressing whether a judge can use 58A4, that's the reconsideration, to redetain someone already released without complying with the stricter requirements we just discussed. So the interaction between the two statutes may have never been litigated at an appellate level. I did about an hour's worth of research. I couldn't find anything.
So what do they call that in the law? Is that a case of?
Could be a case of first impression, which
Right.
means they're dealing with a statutory interpretation without clear precedent. But here's the thing. So for the Commonwealth and the trial court, 58A4 explicitly states that hearings may be reopened by the judge anytime before trial if there is information not known at the time of the hearing or that there has been a change in circumstance. The statute doesn't say, but you can like re-detain. It just says, reopen and reconsider.
Okay. And the judge is saying the inability to use SCRAM was new information.
Right. But here's where I need to there's two sides of that point, right? First, she's saying that Fitzsimmons was manipulative, right? She was manipulative because she already knew from her release paperwork, the medical note that's in here, that there would be some difficulty breathing. So, but then the judge knew that as well, because that's nothing new, right? That they already knew that she had these injuries. So how can she say this is new information to me, but it was manipulative on her part when they both knew the same information?
Yeah. Like you said earlier, you can't know until you know, like in terms of how hard that thing is going to be able to use, it's like
Exactly.
until you try to use it and you're like, holy shit, this is like killing me. It's like, this is horrible, and she fights through it and fights through it. And then finally she's like, I can't continue to do this shit because it's like, it's unbearable. So, I mean, once she finally starts to use the SCRAM. Nobody knows with certainty that she couldn't do it. So in the
Right.
medical notice filed September 8th said that she had breathing difficulties from the gunshot injuries, the collapsed lung and the broken rib. So, but knowing that you have breathing difficulties is different from knowing that you can't generate sufficient breath for a specific device.
Or that it's going to be like so painful that it would be next to impossible. Sometimes impossible, sometimes just so painful that she's coming back. So technically, it kind of bites both ways. It bites against the judge's manipulation argument, but could be considered new evidence for the judge to fall back on reconsideration, not revocation.
Yeah. I
The
mean,
problem, the problems emerged after she was already released. So when they come to court and the court's learning it for the first time, that it's not just difficult, it's next to impossible, or it's, causing her, all of this pain.
but doesn't that cut against the judge's manipulation finding? If
Yeah.
it's new information, how could she have raised it earlier?
Exactly. And that's the internal contradiction in the order. The judge wants it both ways. She wants it new enough to justify her 5-8, under 58A reconsideration, but also something Fitzsimmons should have disclosed earlier, making her failure to do so manipulation.
Yeah, well, both those things can't be true.
They can't. And the
Right.
contradiction is one of the vulnerabilities in the order. But let me give you the defense arguments before, like, the defense arguments on that grounds. For the defense, section 58B, so that's the harder one, exists specifically to protect people who have been released from arbitrary redetention, arguably which is happening here. It says a person who has been released. So I still think there's a that this should stay under 58B for that. I do, but I also see a way that maybe they'll say, well, it is new information. So it says a person who has been released and requires specific findings before taking them back into custody. The legislature created those protections for a reason. If we let judges use 58A4 reconsideration to circumvent them, we're reading 58B right out of the statute.
You can't do both. I mean, both statutes have to mean something, right? I mean,
Right. And that's going to be a thing with the Supreme Judicial Court because it's the rules of statutory interpretation. They say you have to give credit, give effect to all provisions. You can't interpret one statute in a way that makes another meaningless. So you can't interpret one to say, well, I released her and I found new information, so now I'm going to re-detain her, when another statute says in order to re-detain, you have to make these findings.
okay, so which interpretation wins, counselor?
I don't know. Without precedent, I honestly don't know. It's a toss-up. So that's why I kind of revised my initial assessment that this was really strong under 58B, leaving open the possibilities that the court could find 58A.
Wow, everybody wants a refund. I mean, you can't even make a call on it. So, I kid. What should the defense argue on an appeal?
I mean, this is where legal strategy works. Don't lead with the novel statutory interpretation question. Focus on what both statutes require. I mean, Section 8 of 58A2 still requires the courts to impose the, quote, least restrictive conditions of release. So, and 58B requires a finding that no conditions would reasonably assure safety or compliance. So under either statutory framework, the judge has to consider the alternatives. She has to can try to do something that doesn't just say, all right, I'm incarcerating her. And she explicitly didn't do that here.
So are you saying that it doesn't matter whether we call this a reconsideration or revocation?
Exactly. Even accepting the judge's characterization, like that this is under 58A4 reconsideration, she still had to consider whether there were less restrictive conditions like the urine testing that would work, and she didn't. And, that's an error under either statute.
And that's actually a cleaner argument because it avoids like the whole interpretive question entirely.
Right. You're not asking a single judge to resolve a novel question of statutory construction. You're saying, look, at what the statute the judge relied on actually requires. It requires considering alternatives. She didn't. Reverse.
Boom, done. See ya. Take care. Yeah, and one of the things that I think that has to be taken into consideration, and which is an interesting thing to think about, in light of the fact that the Commonwealth had no objection and had not filed for a revocation. I mean, how much are they actually going to fight this thing? You know what I mean? It's like now they're being forced to like support the judge's side of this when we know that on the front end of this, they didn't give a fuck. They weren't trying to revoke her.
It's
You know what I
probably
mean?
probably a different department, and I would venture to guess that they're going to go to bat for the judge hard,
Yeah.
regardless of what their opinion is on the issue. Like they're going to back the judge hard.
Well, what
But
about a timing issue?
well, on August 28th, the initial dangerousness hearing, no SCRAM was ordered yet. September 8th, the medical note is, well, when she's released, SCRAM is ordered. Then you've got September 8th, medical note filed, SCRAM installed that afternoon. The 8th through the 10th, she tries to comply. She has severe problems. September 10th, the emergency motion is filed. September 11th, the hearing. So, from the time SCRAM was installed until the time she came back to court, it was 3 days. 3 days in which she's trying to comply despite pain. That's pretty, prompt.
Yeah, I
And the
would
medical,
consider that to be like dragging ass.
right,
You know,
manipulating.
Give the old college try, as they would say.
I mean, the judge is trying to act like, oh, she knew she couldn't do this. She knew she was going to come back and do this. She just let me release her just to come back and say, hey, get rid of that thing that you really thought was important. But again, the judge can't have it both ways. She cannot say this was new information. It was a change in circumstances that allows her to reconsider instead of go to a revocation hearing, which is what she wrote in her order, and that Kelsey was being manipulative, because either you both knew the information or you both, despite knowing the information, didn't know until she tried just how difficult, impossible, painful it was going to be.
Yeah.
I mean, it shows that she disclosed the material issues right away.
Yeah.
And the judge had the medical note before she was released, so it's not new information. The
Yeah.
only way it's new information is if Kelsey wasn't being manipulative, because Kelsey only realized it after the fact as well.
And I mean, how could she have been being manipulative when she has no fucking idea?
Yeah.
Like that's the part of it that's so just nonsensical.
Right.
Boy, the dog's going nuts outside. I don't know why. There must be.
Are dogs outside?
I think so. But I saw a bunny dip the other day. Like the
Or
bunny.
maybe one of the kids put him out. I'm like, I didn't put him out.
Yeah, it's potentially. All right. So as far as the ADA side of it, let's talk about the arguments in that context. I mean, does it matter whether this is a section 58A or B for disability law purposes?
No, doesn't make any difference. No.
Okay. And what does the ADA require here?
I mean, same thing we said before, a reasonable modification of policies, practices, and procedures to accommodate. So, if the court knew she had disability affecting her, injuries affecting her breathing, she should have addressed that beforehand. This isn't a change in circumstance to her, unless it wasn't manipulative.
Yeah.
She's got to pick.
Right. And I mean, that means considering whether alternative testing would have served the same purpose without the physical impossibility. And once again, a piss test does that.
It detects alcohol use.
I'm assuming that she can pee without pain.
Right. It can be done frequently. It's a standard practice in courts across the state. The judge's order actually makes the ADA violation worse because she says she chose SCRAM specifically to minimize travel. What? Meaning convenience was already part of the calculus here. And again, like I said, if she wants to minimize travel, then she can send somebody to the house.
Yeah. And look, I mean, I think what it showed is that initially the judge was trying to choose a method based on convenience. So that means that she should be willing to change it based on medical necessity, which I think probably trumps convenience.
Yeah. Yeah. I mean, again, she's saying minimize travel. I think like she doesn't want her out of the house, which it's just this again. When you fall back on the underlying case, who she is, she's not dangerous. This didn't involve driving. She wasn't driving, recklessly driving, vehicular homicide, nothing. So what does she give a shit if this woman, has to leave the house?
Yeah, it's not like they're not going to have her on GPS monitoring.
Right.
You know what I mean? It's like they know exactly where people are. I mean, I guess, I always say with these TROs is just a piece of paper. The reality is that a TRO isn't stopping anybody from doing anything. I mean, the Aaron Spencer case is a perfect example of that. Fossler had a stay away order. He didn't give a shit. It didn't stop him from going and getting his filthy claws back into that girl and getting her out of the house. So, I mean, if somebody's got it in their mind to do something, a piece of paper is not going to stop them. But, the fact of the matter is that we're not dealing with Michael Fossler here. We're dealing
Right.
with a woman who was dealing with postpartum depression and, maybe some other kind of mental health issues, and including probably a drinking issue, but so we're not dealing with somebody who is truly, in the sense of a word, like a threat to public safety. That's just, it's like, this was a one-off situation. And,
Right, but the judge put in her order and the Commonwealth will probably argue, that the alcohol monitoring was essential to the release, given evidence of intoxicated aggressive behavior, and that they need real time, breath testing from home was necessary rather than periodic urine testing required her to leave the house.
does
But
that work though?
I don't think so. First, under the ADA, doesn't allow the court to say, well, this practical method is important, therefore, no accommodation. And again, you want random testing and you don't want her to leave the house. You take the people you pay to do these things to go drive to the house. So you've got to inconvenience them. Oh, well. You have to
Yeah.
show that no reasonable alternative exists. That's a reasonable alternative. I mean,
100%.
if they can't get the transdermal SCRAM bracelet, I mean, they do exist. That's something else, and that would be all the time, whenever, 24 hours a day. And urine testing can be frequent as frequent as she wants it,
Yeah.
and it's
And
highly
look,
reliable. So what the
and
hell's her problem?
if they're hell bent on alcohol monitoring, the fact is there are alternative methods. I mean, that's bottom line.
Right.
All right. So give me your honest, revised assessment, taking everything into account: the statutory interpretation, uncertainty, the new information argument, having some merit or not, the internal contradictions in the order. What's the realistic probability that she wins this appeal?
Well, I think she's going to get some form of relief. The question is, are they going to send it back for a full hearing? Are they going to rule right then and there? I don't know that she's going to get everything, but I suspect that they're not going to leave it. They're not going to leave it like this,
I think
Com-
she's going to get out. I think that they're gonna reinstate the conditions of bond so that she gets out of custody. That's what my guess is.
Yeah.
So, all right. I mean, is there anything else you think we need to chat about?
Well, Akasha says Bob did not say hello to me in the glare. Oh, I just plopped off of here. In the
Well, hello, Akasha.
Glare's house.
I didn't even see you in there. So apologies.
So he says hello now. Nay has been a member for 15 months. Thank you. Love
Family
DD. You two are the best. Robin G says, thanks for covering Kelsey's case. Thank you
Definitely.
for being here. Terry Sue, love you guys. Well, love you too.
I'll be
What
back.
does Nancy get, babe?
Family hug. Big
We love-
old family squeeze.
We love our new members. Bob must be wearing a Voodoo Fest shirt. Yes, he is.
Bingo. Cajun gumbo, you know.
It's coming up. It's coming up.
Yes.
Scott McGinnis says the irony that Kelsey's case is in Salem, Massachusetts in October, sending a woman to burn at the stake for witchcraft since 1692. Sending women. Women getting railroaded in Massachusetts over corruption. Again, history repeats. Yeah,
For
it
real.
sure does.
Thanks, Scott.
And Melissa Filson gifted a Defense Diary membership. Thank you
Oh,
very
thank
much.
you, Melissa.
Legal Onlooker says, could a request for the evil robbed witch to be rescued have been part of the
Recused.
recused, sorry. To be they did make it sort
They
of part of
did.
it. Yeah.
Yeah.
Is she on this case for its entirety or she's on the case for the entirety?
Right.
Unless they take her off.
Right.
So they're asking. They might tell them to go back and do something more. But Legal Onlooker followed it up with the judge lives in the same town next to me. Wonder if she has a connection to the cops or even the ex. She mentioned Noonan a bunch of times.
Interesting.
Interesting. I mean, seems like there's something underlying her attitude.
And then Kale, and thank you, Legal. Kale asked if more Garcia soon. Yes. I was the hope was to get it done by today, but it'll be in Darren's hand by midweek. And they're talking about our second season of the podcast, Tunnel Vision, which is covers the Anthony Garcia case. Good old episode 69, babe. Good old episode 69. Yikes. All right, y'all. Tomorrow night, and just so you know, I'm jumping on from our live onto Danny After Dark tonight in like 5 minutes, actually. So maybe follow us over there. Should be an interesting conversation. I don't even know what she's going to ask me about. I'm assuming all kinds of stuff, but we had met her most recently at the True Crime Podcast Festival, and she had asked me there if I'd come and join her on her channel. I said, of course. So we'd love to see you over there. Again, that's Danny After Dark. And then tomorrow night, none other than Andrew Baldwin will be joining us at 6:00 p.m. Central Standard Time to talk about the new news on the Richard Allen appeal, which we got some of that today. And then he's also going to be talking about the case that we covered a couple months back. There's a new 48 hours coming on, and it was another case that Andy tried in front of none other than Judge Gull. Got a very different result in that case, which was a not guilty, but it's a fascinating case. It's kind of like another the staircase, except the gender roles are switched. It's the wife who was accused of killing her husband. But she was acquitted. So Annie's going to be with us tomorrow night to talk about all that stuff. We'll hope you join. Make sure you're hitting your notifications. Make sure to please like, share, and subscribe. If you love the show, become a member. We love our members. We really, really love our members so much.
Thank you,
And
Jody.
thank you to our mods. We appreciate you guys so very, very much. We couldn't do this without you, specifically Mandy and Tracy. We adore you both. And you guys, all of you out there that are with us day in, day out, we couldn't do this without you. And frankly, if you weren't here, you know what it would mean? I'd just be an old man.
Sitting around talking to his wife.
Boop. See you.